Right. Good morning, everybody. And welcome to our webinar on the appropriation of liability and for different workforce models. I think for those clients and TESs that are on the platform and on the webinar, it is important that we understand as businesses where our liability starts, where it ends, who's responsible for what, and how do we co-work a solution that we cover our liabilities and still remain within the ambit of the various laws. I think one of the things, if I look through the initial invitation, there's so many aspects of laws and laws that affect the way we do business and the industry that we're in, that we need to be very aware of what the liability is, what the risk is, and how to effectively manage it so that we can remain compliant suppliers to our clients, and the clients can have the assurance that the broker that he is using or the TES is compliant and understands where the risks lie. So those of you that don't know John, he's been around for many, many years, and he specializes in this type of industry, the alternatives, the way workforces are strategized and how we transform and plan them. He's had years of experience with large major corporations, and it's always a pleasure to have John and his insights, because they look at things from a different way. We are operational most of the time. They look at it and say, well, what are the alternatives? Where is the risk? And John, once again, welcome, and thank you for your insights that you're going to share with us.
Well, thank you, Albie. Good morning, everybody. And I do hope you can hear me. I've just had to pull over out of the traffic, and I'm just sitting at a place on the side of the road. So I hope that all is good. And thank you for the invitation once again, Albie, to you and Krista and the team. It's a privilege to always be with you. And I really hope that I can share a bit of insight. A lot of what I'm going to talk about, of course, you will be aware of. So it may be a refresher for some, but for others, it might actually spark some insight and maybe some creative opportunities for designing even more compelling propositions for your clients going forward. So I've taken a very simplistic approach today. The slides are with Krista, so she will make them available to you if she hasn't yet done so. So I'm just going to talk off the top of my head. I'm going to just share some thoughts, and you're welcome to post questions in the chat box. Alternatively, we can maybe have a Q&A as well at the back end of it. If you can mute your mics, I can hear some feedback. So there we go. So colleagues, the workshop that we decided to run today as part of our journey, which we've been on for some time, we've covered interesting concepts. We've covered labor law developments. We've covered different models, workforce models. We've looked at different angles to things, and maybe a future one, Krista, and I'll be a future session we can run is on artificial intelligence and how it impacts the industry and opportunities to optimize AI. But for purpose of today, we're going to be looking at liability and the appropriation of liability. There's no doubt that the labor law framework is just growing and growing in South Africa. I mean, as we sit here now, we're waiting for the president to sign the National Health Insurance Bill into law today. Of course, there's a lot of opposition in terms of that, a lot of opposition to the NHI bill. Of course, colleagues, the overriding sentiment is that there's a lot of electioneering taking place. I mean, if you just think about it, today the NHI bill will probably be signed into effect. We had the hate speech bill that was promulgated 4 days ago. We've had the two-pot pension fund system, which was which is going to be given effect to on the 1st of September. We've got the Employment Equity Amendment Act, which has been assented to. So you can't help but get a sense that it's quite incredible how all this momentum just gets found so close to elections. Now, I'm not saying those bills are not necessary. I mean, the hate speech bill is a very important bill. The two-pot system will give employees access to some of their pension fund as savings every year. The Employment Equity Amendment Act is necessary because transformation hasn't been what it should be. But the reality is, colleagues, we've got more and more and more and more laws coming through. And our job is to try and make it easier and simpler and less risky for clients. Because if they go on their own, they're just going to pick up more and more liability. So my challenge to you today as we go through this is to say, how do we use this legislative framework to our advantage? How do we take what is happening and we take the pain as much as possible so that the clients can get on with their business? So that is really the objective of today. Now, if we take a look at, and I'm going to build incrementally, so it's important that you stay with me, because what's on the screen now is going to be the basis for the entire session today. So if you look at the applicable laws, I've called them workforce laws, workplace laws. In other words, we've been forced to move away from narrow employer-employee related laws because there are many other laws that impact the workplace and their employment relationship. So, of course, we start off with the Labour Relations Act, and the LRA remains a big aspect and a big component of workplace dynamics. Of course, when we look at it, we see, of course, the LRA, we'd have to continuously deal with unfair dismissals. Unfair dismissals for misconduct, incapacity, operational requirements, also reasonable expectations of renewals when it comes to fixed-term contracts. So unfair dismissal is always going to remain a massive part of our landscape. Of course, unfair dismissals also have a differentiation between employees earning below the threshold and above the threshold. And of course, the liability appropriation is different for, whether you earn above or below the threshold. Then we've got unfair labor practices. So under the Labour Relations Act, we also have Section 186, unfair labor practices, which deals with unfair promotion, demotion, training, provision of benefits, and also unfair suspension. And the Labour Relations Act then obviously also extends to strikes, lockouts, organizational rights for trade unions, and Section 197 transactions. And one of the things that I'm coming across a lot more is companies that are doing mergers, acquisitions, and other types of subcontracting and outsourcing. They often don't know how to deal with temporary employment services in the context of a Section 197 transaction. So to start off with, I'm putting on the map the LRA and the whole question of who is liable for what under the LRA. The next area is the Employment Equity Act. Now, unfair discrimination is very clear in my mind. You can't unfairly discriminate on race, gender, sex, disability, sexual orientation, and all those types of grounds. The question, of course, is who's liable for what? If you do unfairly discriminate, when is the client liable and when is the temporary employment service liable? We then look at the Employment Equity Act, but from the point of view of affirmative action. So if you look at Chapter 3 of the Employment Equity Act, and now I want to make a statement, and I hope that you're all paying attention, because this is a fundamental statement I'm going to come back to later on. I would assume that 90 to 95% of all of you on this call today are acting in contravention of the Employment Equity Act, Chapter 3. And I'll explain to you why later on, but it's got to do with compliance with committees, employment equity committees and forums, workforce analyses, employment equity plans, and employment equity reports. And if we look at Chapter 3, read with Section 57 of the Employment Equity Act, colleagues, I've got a major concern about who reports on your TES assignees. When do you report on them and when does your client report on them? And I'm suggesting to you that if you get it wrong, you are putting yourself and your client in danger of not getting a certificate of compliance off the back of the amended Employment Equity Act. And if you don't have a certificate of compliance, as you know, you will not have access to public sector tenders, private sector tenders probably as well. And of course, if you don't have a certificate of compliance, there are significant economic and financial implications. So you need to get your head around this issue of employment equity reporting and compliance. Then we've got the Skills Development Act and the Skills Development Levies Act. And below that, Bargaining Council agreements, sectoral determinations, and the Basic Conditions of Employment Act. We then have UIF, Workmen's Comp, the Occupational Health and Safety Act, the POPIA Act and the Cybercrimes Act, and now you start seeing a broadening in the world of legislation, because a few years ago we didn't have to deal with the POPIA Act. But since June 2021, the POPIA Act has become a central part of our landscape. And you are processing massive amounts of personal information, your clients processing massive amounts of personal information of your TS assignees, and you need to ensure that you are covered contractually and in terms of compliance with the POPIA Act in order to avoid significant penalties. We then have the Cybercrimes Act, which deals with the unauthorized access to systems. The Cybercrimes Act also deals with aspects of harassment and intimidation online on digital platforms and unfair discrimination. And then finally, for today's purposes, we've got the Income Tax Act. Now, I can add more laws to this. For example, the PAYA Act comes into the scope. I haven't put the hate speech bill in here. They are very recent developments. The point is you've got all these laws, and the scope of laws is continuously getting broader and broader and broader. Then you've got case law, the Barlow World Enver case around cannabis, and how organizations approach the issue of cannabis, because a zero tolerance rule is no longer acceptable at law. You can't have a zero tolerance rule on its own. There's got to be a merit-based approach, and we've run a webinar earlier this week and last week on cannabis and the impact of the Barlow World judgment on whether you are allowed to deal with traces of cannabis or whether you also need proof of impairment. And that must happen in the context of safety-sensitive jobs. So some jobs are safety-sensitive and others jobs are not safety-sensitive. Now, effectively, what I'm suggesting and I'm asking is, are you absolutely sure that you are on top of these issues when it comes to the relationship between you and your client, in particular, the appropriation of liability? That is the focus of today's session. So I'm now building off this, and I'm saying on the left-hand side, in the left-hand column, you've got the various laws. Now I'm talking about various workforce models. Now I'm starting off with a case where the client decides they want to do it themselves. So if there are clients and they say, well, we want to do it ourselves, we don't need temporary employment services, we don't need subcontracting and outsourcing and functional outsourcing, we are so good, we're going to do it all ourselves, well, then they've got a problem, because as you can see on the screen, colleagues, if companies employ their staff directly, they are liable for all of these laws themselves. In other words, whether they employ people permanently, part-time, fixed-term contracts, the bottom line is they are being very, very, very silly, because they are picking up liability for all of these places, for all of these laws. And not only do they pick up liability for all of this, but they need to have the internal skills and the systems and the standard operating procedures to deal with all of these things themselves. And you know as well as I do, in a very volatile and uncertain environment, you need to be agile. There's no way that a company can be agile in this world if they do all of this and deal with all of this and take all of this liability on themselves directly. So you might still have a few companies that think they can do this, but they are very narrow-minded. And I'm worried about those companies because they're not going to survive. Right. Let's look at the next add-on. Let's say you've got a client who now says, we want to look at using temporary employment services. We realize that we need to mobilize and demobilize staff very quickly. We know we need the skill sets at the right time. We know that we need to have strategic partners. We can't do all of this ourselves. So what are the benefits of using a temporary employment service? So what I now have is I've taken the laws and I now look at the appropriation of liability between the parties. So on the second, or in the second column, that is where the TES is severally liable. In other words, the client is not liable, it's only the TES. Then I've got an area where the client is severally liable. In other words, where the client is liable on its own. And then I've got an area on the far right, which is joint liability, in which there is a shared liability to some extent between both the client and the TES. So what you can see already in this heat map, if you look down the middle, the client is liable for the Occupational Health and Safety Act on its own. Okay, very important, colleagues. The client is liable for occupational health and safety. That is in terms of Section 1 of the Occupational Health and Safety Act, which says that because the client is managing the premises, because the client has got control of the infrastructure and issues the instructions to your TES assignees, the client is liable for the OHSA Act. And you need to be very careful in your service level agreements, because often your clients try to make TESs liable or jointly liable for the occupational health and safety aspect. But at the end of the day, that is not legally acceptable. It's not sound, and you need to push back, because when it comes to a TES proposition, you do not control the operations of your staff members. Your client is issuing the instructions to the staff. Your client is telling them what equipment to use. Your client has to take responsibility for occupational health and safety. But let's go back to the top. When we look at unfair dismissals, colleagues, if employees are earning below the threshold, as you know, it's been revised recently. I think it's to just over 250,000 Rand per annum, or 20-odd thousand Rand a month. So if people earn below the threshold, the TES is liable for unfair dismissals in the first 3 months. And then after 3 months, there is a co-liability. So under the LRA in section 198 capital A, that says that after 3 months, for purposes of the LRA, the client is the deemed employer, but the TES has got locus standi as well. In other words, the TES is fully entitled to appear before the CCMA and the Labour Court because it is a co-respondent and it has got standing legally in that environment. So it makes absolute sense for a company to use a TES, but you need to ensure, colleagues, that you as the TES have been given a written instruction by the client that they appoint you as the agent to chair disciplinary inquiries, to deal with disciplinary matters of misconduct, to deal with grievances, and so on and so forth. If we look at employees earning above the threshold, if you've got TES assignees earning above the annual threshold, well then, colleagues, the TES is severally liable. So it makes absolute sense from an unfair dismissal point of view for your clients to use a TES because you're the agent, you do the discipline, you do the grievances, you do the poor performance management, and so on and so forth. When it comes to unfair labor practices, it's a very similar scenario. Generally, in the first 3 months, the client is, the TES is severally liable, and then after 3 months, there is co-liability for people earning below the threshold. And I think it's going to become more and more interesting because often your assignees, your TES assignees are excluded from training interventions. They're excluded from career and succession planning opportunities. They might be excluded from, applying for vacancies. And I think that's going to become a problem because after 3 months, they've got the legal right to be part of the opportunities to apply for vacancies and to have access to training, writing that in to your service level agreements. And it's good for the client as well, because it allows the client access to more resources and more opportunities for entry-level pipeline skills and to support the employment equity ministerial targets. Anyway, let's move to the Labour Relations Act now in terms of Section 197, strikes, lockouts, and the like. Now, colleagues, after 3 months, if employees earn below the threshold, remember, after 3 months, they become part of the client's deeming landscape. So when it comes to strikes, when it comes to Section 197 transactions, your assignees are part of that landscape. They're part of that process. If ever your client sold all or part of its business, if your client subcontracted all or part of its business, and you had TES assignees in that ring-fenced area that is being outsourced or subcontracted, your assignees are part of a Section 197 transaction. And that's very important because if they do not go across as a going concern, or if they are not transferred as part of that, you will be in breach of Section 187, could be an automatically unfair dismissal. So you must be very aware that when your client sells part or all of its business, subcontracts or outsources, if you've got TES assignees in that environment, they also get automatically transferred. So it creates a contractual obligation between you and the client and the new employer. So let's just wrap up on the Labour Relations Act. Effectively, if your assignees earn less than the threshold, then after 3 months, your client is the deemed employer, but you have locus standi because you've got a vested interest in the outcome of that engagement. Now let's move to the Employment Equity Act, unfair discrimination. Colleagues, very, very important. Unfair discrimination on the basis of race and gender and sex and sexual orientation and culture, etc., unfair discrimination is in the realm of joint liability. I want to refer you, and I'm going to get there later on, but I want to refer you to, if we look at this particular slide, Section 57, subsection 2 of the Employment Equity Act. And Section 57, subsection 2 of the Employment Equity Act says that if the TES acts on an instruction of the client, and that amounts to unfair discrimination, you are jointly liable. Now, I want to give you an example here. Just think of this example. For those of you who are familiar with the Enver Barloworld cannabis judgment, you'll remember that Enver, she worked in a white-collar office environment. She used cannabis recreationally and for medicinal purposes. She used it regularly, frequently, and when she came for her annual medical checkup, they picked up traces of cannabis in her system. She was not impaired, colleagues. She did not have red eyes, a dry mouth, or any cognitive challenges, balance issues, or out-of-body experiences. She was fine. Even though she used cannabis regularly, she was fine. And obviously, they picked up traces of cannabis during an annual medical. They then ultimately dismissed her because they had a zero tolerance policy. I want you to imagine, what if Enver, the employee, was a TES assignee, and the client insisted that you dismiss that person because of traces of cannabis? And let's say that you ended up in the Labour Appeal Court, as did Barloworld, and you and Barloworld were found jointly liable for unfair discrimination on an arbitrary ground. Can you see where I'm going with this section, colleagues? You see, if you act on an instruction of a client and it amounts to unfair discrimination, you and the client are jointly liable, and it doesn't end there. Because remember, if you found guilty or your client's found guilty of unfair discrimination 12 months before your annual employment equity report is due, you will not get a certificate of compliance. Can you imagine the consequences of that on Barloworld, the consequences of that on your business when you can't tender for public sector work, and potentially even in the private sector, the procurement departments won't give you work because you don't have a certificate of compliance. So you need to be extremely careful in terms of unfair discrimination, where your client instructs you to do things that could be unfair discrimination. The next part of the Employment Equity Act is the reporting issue. Now, colleagues, if you look at Chapter 3 of the Employment Equity Act and Section 57, subsection 1, I want you to write this down. I want you to go and read it. It says in Section 57, subsection 1, that for purposes of Chapter 3 of the Employment Equity Act, after 3 months, the client is liable for compliance. There we go, where my cursor is. After 3 months, and it's not related or linked to your earnings. We're now in the Employment Equity Act, and it says after 3 months, for purposes of Chapter 3 of the Employment Equity Act, the client is liable. Now, I want you to understand Chapter 3 of the Employment Equity Act firstly says that a designated employer needs an employment equity committee, representative of all the interest groups. Secondly, it says in Chapter 3 that companies need to do a workforce profile analysis, they need to do an employment equity plan, and they need every year to report on that plan to the Department of Employment and Labour. That is what Chapter 3 of the Employment Equity Act requires of designated employers. And now Section 57 says that after 3 months, it's the client's responsibility to do everything that I've just explained to you. Now, can you imagine an inspector from the Department of Labour pitching up at your client and saying to your client, do you use TES? And the client says, yes, we do. And then the inspector says, okay, let me see the members of your committee. Oh, why don't you have a representative from the TESs who've been placed for longer than 3 months. Why don't you include the statistics of race, gender, and disability across your occupational levels for the TES employees for after 3 months? If they've been on your premises for more than 3 months on a contract, they are your obligation, client, to report on them. And by the way, are they included in your EEA2 and your EEA4 submissions every year to the Department of Employment and Labour? And that is why I said earlier, I reckon 90 to 95% of TESs are not complying with this, and that has got huge issues. It can result in significant fines. It can result in losing a certificate of compliance. So you are going to have to start becoming a lot more aligned to your clients and sit with your clients and say, when is your cutoff date? When do you do your stats? And you're going to have to give your client the certainty that you're giving them the statistics of the assignees who've been placed for more than 3 months. So colleagues, the Employment Equity Act is a massive area of risk that you need to address. Of course, the Skills Development Act and the Levies Act, the SDL, that is the TES's liability. So that's not a big ticket item. You do your 1% SDL payments, you submit your WSP and your ATRs, and hopefully you're getting back some money in that regard. Basic Conditions of Employment Act, colleagues, and bargaining council agreements. We see a great deal being signed between MEIBC stakeholders yesterday, and well done to that negotiating team. And I think it gives certainty. But the bottom line is, if there are breaches of Basic Conditions of Employment Act, the TS is liable, but the client is also liable. So if you take a look at that, I'm going to come to it later on. But if you look at section 82, subsection 3 of the BCEA, basically the client becomes liable if the TS defaults on basic conditions, bargaining council agreements, sectoral determinations, and the national minimum wage. I can't believe that even now, many companies are not calculating proper overtime, not calculating proper Sunday time, wage rates. Companies are getting overtime, night work. All of those areas are still not being complied with by certain businesses. The other thing under the Basic Conditions of Employment Act, colleagues, which I find is very important, is the issue in respect of equal treatment after 3 months under the LRA. So, you know, to what extent are you providing the same leave, the similar leave and sick leave and parental leave benefits to your assignees when compared to your clients? So basic conditions, very important. Please be aware that you are liable, but you're also placing your client potentially in a position of liability if you do not comply. Santi, over to you. You're welcome to unmute.
Good morning. Thank you. I'm not sure if I can ask a question now or reserve it for later.
Go ahead. Go ahead. No problem.
All right. So if I have a client that does not belong to the BCCI or the MEIBC, but the company that I work for does, and obviously it's compulsory for us to, you know, for employees to join a pension fund or pay the year-end bonuses because we belong to, you know, those bargaining councils. What if the client then says, but I can't afford to do that? Do you apply for exemption specifically for that client or as a whole? How would you go about that?
Santi, as a general rule, and thanks for that question, you know, as a general rule, you have to comply with the industry in which your client operates. So obviously, if your client falls under the MEIBC or the Bargaining Council for the road freight industry, you have to run your payroll and structure the benefits based on the jurisdiction that your client finds itself in. Now, if your client says to you, yes, I can't afford this provident fund payment, or I can't afford these minimum wage rates, or I can't afford the annual increase, Santi, then the only way around that is to assist your client and try and apply for exemption. But if exemption is not given, well, then, you know, it is what it is. Your client's got to comply. So that's part of the challenge. And when we take a look at this matrix on the screen, that's exactly the challenge, you know, because if your client is not compliant, it actually puts you as a TES in danger, because you jointly liable with your client under let me just go and see the exact section, under section 82 subsection 3 of the BCEA. So that's why, you know, you've got to be so careful to ensure that you've got that the demarcation of your client in that industry is clear. I hope that answers the question.
Yeah, sort of.
No, we'll go for it. I mean, we've got colleagues here that can help me answer.
Yeah, so my actual question is then, because say for instance, I have different clients, obviously in one bargaining council, but the one client doesn't have a problem, you know, because they belong to that certain bargaining council, but the other one don't. So then the other client would say, let's refer to client A and client B. So client B would say, look, we don't belong to the bargaining council, you belong to the bargaining council. But now what you're telling us, if our company who supply the service belong to the bargaining council, then it obviously defaults to us. So, but if our client then says, but I can't afford it, but client A can, and they also belong to it and they comply, do you then apply for exemption only for client B? Or do you apply for exemption for you as a whole? For all your clients, or only for that specific?
I see my good friend Kevin is going to help me answer this. Kev, over to you.
Yes, very simply, if you operate within the auspices of a bargaining council and there's a collective agreement or a main agreement, whoever operates in that environment, whether they're a member or not, whether they are registered or not, they are obliged to be compliant. So the client in your life who's giving you trouble needs to wake up and decide whether they want to operate in that council or in the auspices of that agreement, because not just the council agreements, they cover both parties and non-parties. And the non-party is someone who does not normally operate in that particular industry. Once they become involved in the industry and they are supplying skills that are dedicated to the collective agreement, they are automatically liable. You will also be liable. In terms of Section 198, as John said, there will be further liability in terms of the 3-month period and what happens after the 3-month period. Your client would unlikely be allowed to get exemption from the council's main agreement, collective agreement. Because they do not want to set precedents. They will give exemption in terms of aspects of the agreement, and it'll only be for a temporary period if there's sufficient motivation, and obviously you have to present your case to the inspectorate of the council. So I hope that helps you. Thanks, John.
Yeah, so would I, thank you. So would I then apply for, sorry, I don't want to waste everybody's time. Just want to make sure that I have it right. So when we apply for exemption, would we then apply specifically for that one client, and that one client has to then give, submit their financial statements, because that's part of when you apply for exemption, so that you have to have proof that you can't afford it. We as CSG doesn't have to, because we apply on behalf of our clients, so they then have to submit their documents. Is that right?
they have to apply themselves. But as I said earlier on, they would not get the exemption from the council. It'd be very unlikely. What council is the MBC RFLI, or is it MERBC?
BCCEI.
BCCEI more difficult. So that's your chemical and related allied. They are going to be very, very, I'll say it in good words, hard asked about allowing any application for exemption, because all they do, you do need to open a book to other applicants. As I said, they will look maybe at a partial exemption, but that would be for a short period of time, and that would need to be very well motivated, not by yourself, but by your client.
Yeah. All right. Thank you. Thank you, Kevin.
Pleasure.
Santi, yeah. So I think just in summary, and as Kevin correctly indicates, you know, the point is it's your client who has to do the application. Your client falls within that scope. So these agreements, as you know, are extended to non-parties, and it's really your client that is the primary driver of compliance, as well as in applying for exemption. So if it's just that client that needs exemption, well, then they must pursue the exemption process. But outside of that, they've got to comply, obviously. LB, over to you.
For my 2 cents worth, and I totally agree with what Kevin said. The bottom line is that if we want to be compliant in terms of our own compliance, what about the employees that fall under that bargaining council that are not TES employees? Surely they need to register those people as well.
Correct. Correct. So I think the essence of this is your client is the point of departure. The industry they fall in is the industry that has jurisdiction. If there's a bargaining council agreement, then they have to comply with that agreement. Even if they're not direct members, it's extended to non-parties, and they then got to, as the client, they got to proceed. Of course, you can help them in achieving those exemptions. So colleagues, in terms of that, we move on to UIF, workmen's compensation. Of course, it's the TES that administers that. You'll also know the workmen's compensation, the COIDA amendments, the regulations are going to come through in the near future, and it's going to require very intensive administrative processes for employees that are injured on duty. So that is the reality. We've spoken about the OHSA Act, and then we've got POPIA and cybercrimes. Now, I want to just point out something here. When it comes to POPIA, remember, colleagues, a temporary employment service is what is defined as a responsible party under the POPIA Act. So as the TES, you are processing the personal information of your temporary assignees. You're processing their pay, you're processing disciplinary issues, you're processing benefits funds. So as a TES, you are a responsible party, and you've got to ensure that all your systems, all your platforms are secure, that they are encrypted, that you've got all the necessary safeguards and cloud security in place. And you've got to ensure, colleagues, that your staff members have been trained on POPIA and have gone through the mandatory awareness training. So that's you as a TES. You've got to make sure that there are technical and operational safeguards in place. How do your staff deal with hard copies? How do they deal with personal information? Are they password protecting spreadsheets and other documents containing personal information of your assignees? So it's a very, very, very important matter. But beyond that, colleagues, I want to also emphasize your client is often sending you information on time sheets, payroll information, and other types of biographical and personal information, and you are sending to your client as well. So I am asking you here, have you and your client signed a mutual agreement around safeguarding and protecting the personal information of your assignees. It's a very, very important matter. In my mind, you are defined as an operator under the POPIA Act. Remember, an operator is an organization that processes the information of another responsible party in its environment. And you need to ensure that you've got very tight POPIA agreements with your clients and with your service providers, like your credit bureaus, your credit criminal checks, your license checks, your qualification checks. Those third parties, your pension funds, your provident funds, they are operators, and they need to have a signed operator agreement with you. It's a legal requirement. So please be careful with that, because you are liable as a TES, you're a responsible party, but in certain instances, your client will also be liable, because your client's also processing information about your temporary assignees in its environment for various purposes. So you need to ensure that your client acknowledges that it is compliant with the POPIA Act. Cybercrimes Act, of course, also very, very important. And I think one of the areas that you need to be very careful of is, what about your TES assignees? Colleagues, if you are placing employees and assignees with your clients, and these assignees have got access to personal information in your client's environment, you need to be demonstrating that you are doing awareness creation training for your temporary assignees, because they are in your client's environment. They're using personal information and processing personal information in your client's environment, and you are placing them there. Either you or your client need to be doing awareness creation training in that regard. And just while I'm talking about awareness, the Employment Equity Act, the Code on Harassment, colleagues, remember the Code of Good Practice on preventing and eliminating harassment at the workplace legally requires harassment risk assessments. It legally requires you to do awareness training on harassment, all the forms of harassment, joking at someone's expense, rolling your eyes at other people, constant criticism, any form of conduct that undermines human dignity. Those are all examples of harassment, and you need to ensure that you've covered that. And then, of course, the Income Tax Act. And of course, as we know, TESs are the collection agents and responsible for that. But I think more importantly, if you look at it holistically, if you stand back and you look at what's on the screen, you will see that it makes absolute sense to use TESs from a risk and liability appropriation point of view. And as the list of laws affecting the workplace grow, it's great opportunity for you to tell your clients, don't worry, we've got you covered. We've got you covered on POPI, we've got you covered on harassment, we've got you covered on your employment equity reporting, we've got you covered in respect of dismissals and disciplinary matters. We've got you covered, don't worry. Obviously, you've got to build in certain safeguards to protect yourself, especially because clients still just want you to remove people for the wrong reasons and dismiss them. I'm not saying we must agree to that, but I think on the face of it, there's a great opportunity to demonstrate your benefits as a TES. The other thing, of course, is the smaller your payroll and the headcount, the better if you are a client. So if everything in law is about percentages of payroll and percentages of headcount. So if you look at BBBEE, your skill spend, your learnerships, your SDL, all of those things, number of learnerships, they're all a percentage of payroll. They're a percentage of headcount. So companies that want to just go and do it on their own, like this example here, these companies are doomed for failure, because the bigger their headcount, the bigger their payroll, the bigger their compliance costs become. Because, as I said, everything is a percentage of payroll and everything is a percentage of headcount. And then, of course, it's good for clients to use you because of this liability appropriation and the skills that you bring with you. So let's just recap very quickly. we started off talking about labor laws and clients that employ people directly themselves. And you can see it makes no sense, because in this world we live in, volatile, uncertain, complex, ambiguous, for a client to just go it alone, they're absolutely crazy. We've then gone to the second workforce model, which is a TES model, where there is significant green area in terms of liability sharing and risk sharing, and your clients can benefit significantly from this. And the labor laws are just going to grow. We've cannabis for private purposes bill coming through the ranks. We've got the Employment Services Amendment Bill that's dealing with foreign nationals, platform workers coming through. So this grey list on the left-hand side is just going to grow and grow and grow. And if your clients can partner with you, you will have strong relationships. Now let's go to the third and final iteration. The third one, of course, as we've done in previous webinars, we've discussed the third option, which is independent contracting, subcontracting, and outsourcing. So your functional outsourcing, your managed service providers, your subcontracting, all falls within the scope of independent contractors. Now, independent contracting, as you can see, the buck stops with the independent contractor. So in other words, a company like Pick and Pay that outsource their warehousing and distribution functions to fully fledged operators, functional outsource companies, their Pick and Pay is totally indemnified from these liabilities. It is those companies that are providing those services as outsource providers who control the processes, control the staff, control the equipment, generate the outcomes, invoice for the outcomes. All of the liability stops with those independent contractors. And that is why we've seen this massive growth in outsourcing, subcontracting, and independent contracting, because it not only allows companies to pay for performance, but it also indemnifies them of these laws, as long as it is a truly an independent contracting arrangement and not a smokescreen. And the big problem here is the client needs to let go of control. As we know, the biggest thing is clients want to hold on to control. They think they can do it better, and often they try and have a bastardized smokescreen model, which is actually a TES, but they portray it as an independent contracting model, and they suffer the consequences of that. But you can see here the significant benefits of being able to take parts of your business as a company and to outsource IT, outsource warehouse and distribution, outsource aspects of manufacturing and production. It makes absolute sense to do that. So colleagues, when we pull it together, and this is very, very nice slide, even if I must say so myself, this slide is really incredible from the point of view of saying to a client, listen, the world we live in requires a blended approach. Sometimes you'll lean more to one model, other times more to a different model. But at the end of the day, colleagues, this shows there's where a client employs directly in the second column. That's where the company is responsible for everything. The next three rows show the TES appropriation of liability. So it shows the benefits. And then the last one is where the client outsources or subcontracts, and as a result of that, really absolves itself of liability against all of these laws. On the far right-hand column, I've also included the specific sections of the acts that talk to the TES environment. So if your client says to you, what's this nonsense about employment equity? Why must we report on your temps after 3 months? You can then go to your client and say, please, let's take a look at section 57, subsection 1. There, client, you can see it is prescribed. You know, if your client says to you, listen, what do you mean with the section 197? What do you mean we've got to include TES assignees as part of that transaction? Well, you can go to section 198. A subsection 3, and you can see that after 3 months, for purposes of the LRA, the TS assignees are deemed employees of the client. So colleagues, I really, really want to encourage you to build outwards on this framework, and to demonstrate that the margins you charge, the management fees that you charge are worthwhile, and in fact that your clients really need to partner with you strategically. The other thing is, colleagues, to try and take what's on the screen and to write it into your service level agreements. You know, often you've got in your SLAs, you've got liability and indemnification clauses. And most of those clauses are very broadly written. You know, either party indemnifies the other party of any liability out of the interpretation and application of this SLA. And it's so broad, colleagues. I would highly recommend, as an example, that you say in your indemnity and liability clause, and you say the parties in principle agree to the following rights and obligations as per Annexure A, and then you sort of have this kind of slide and you attach it so that people can see who's liable for what at a high level. Obviously, in many instances, you might have to go into more detail. Well, colleagues, just some general observations from me as we pull this together at the back end of today's presentation. Some of the general observations that I want to make is, firstly, when it comes to TESs, please try and link the projects and the durations to automatic termination doctrine. In other words, when you sign fixed-term contracts with your assignees, really, really try and define the nature of the project and or the termination date. And the reason I'm raising that specifically is if you take a look at this matrix over here, you know, where employees earn below the threshold, what happens is if you remove them and they say they had an expectation of ongoing employment, or if they say that they've been unfairly dismissed, you are facing significant challenges. And the other problem here is Section 198, capital B, which looks at fixed-term contracts. It's very clear. It says that if you do not give a specific description of the project or the duration, it's deemed to be indefinite employment. And as soon as it becomes indefinite employment and you've got to remove those temporary assignees, well, then you're in the realm of Section 189 and operational requirements. So one of the biggest things you need to get right and continuously need to get right is just this management of fixed-term contracts. It is such an important factor, colleagues. The second one I'd recommend when you draft SLAs with clients is certain protocols around the removal of TES assignees. I've drafted some TES SLAs before where we've agreed with clients and we've said with them, if you want us to remove between 1 and 5 people, we need a week's notice. If we go from 5 to 30, it's 2 weeks, and above 30, we need a month. And if it falls in the realm of Section 189, capital A, we need 90 days. You see, colleagues, you need to build these protocols in, or else your clients are continually going to just abuse the situation by telling you to remove to remove employees without following due process. And of course, you're going to incur severance costs, etc., etc. So please try and build in protocols around the removal of people and the time periods attached to that. The other thing you need to be very cognizant of is point 3, your disciplinary codes and procedures. Colleagues, I referred to cannabis earlier, but you know, you need to ensure that your substances policies, your disciplinary codes in terms of sanctions for things like arriving late for work, absent without leave, breaches of privacy and cybercrimes, social media. I mean, we've seen so many matters around social media being litigated on where employees are posting derogatory comments about their companies. they're harassing people online. You know, you need to ensure that your disciplinary codes are keeping up with these trends in this fourth industrial revolution, and as we move deeper and deeper into the fifth industrial revolution. When last was your disciplinary code upgraded to include breaches of cybercrimes, breaches of social media protocols, breaches of substance policies? You know, we've got all of these new developments. What about moonlighting? You know, what is your policy on moonlighting? And so on and so forth. So please align with your client's disciplinary codes, because remember, after 3 months, they deemed employees of your client. So you need to write that into your employment contracts and your SLAs. Beware of your harassment obligations. Colleagues, there was a recent case in ShopRite where a female employee was busy processing an online order, and she was struggling with this order, and she called for assistance, and her male manager came into the office to assist her in processing the online order. The male manager then lost focus and decided he was going to smack the female employee on the buttocks, which he then proceeded to do, and he smacked her on the buttocks. Of course, she wasn't very impressed, and the matter ended up ultimately in the Labour Court, the ShopRite case. You know what was interesting in that case, colleagues, is ShopRite were fined 50,000 Rand because they found ShopRite vicariously liable for the acts of its employee. You see, colleagues, ShopRite were not able at that point to prove that they had appropriate measures in place to prevent this. Like Harassment Act, a judgment like that means that for 12 months, you will lose your particular certificate of compliance. So I want to ask you to please revisit your induction policies and processes, revisit your awareness training. I mean, awareness training should be for health and safety, harassment, POPIA, and substances. You should put together a very, very interesting and comprehensive induction program so that at least you can prove that you've taken the necessary steps to prevent those things from happening. I mean, I'm sitting now just looking at them building a building where I'm sitting now, and I'm thinking of that George building where 33 people have been killed and people are still missing. And you can imagine the investigations taking place in terms of health and safety awareness, in terms of qualifications, in terms of foreign nationals. We see there were 5 Malawians, certain Zimbabweans amongst those people who died, people from Mozambique. And can you now imagine the liabilities that are going to be faced by companies and employers if they didn't properly check and validate all of these things? Of course, under point 6, you are all experts in this field. I'm not going to spend too much time on it, but as a minimum, you need professional indemnity insurance cover. Why? Well, if you do not potentially do a proper reference check, or you do not potentially do a proper credit check, and that's part of your professional service, then of course you're going to be found wanting. You need professional indemnity cover, and then you need third-party liability cover. In other words, if third parties suffer injuries, death, or any form of damages, you need that cover in place in order to ensure that you can be confident, your clients can be confident in that regard. Well, I've said independent contracting is another story. I mean, obviously, if you act as an independent contractor, your insurances that you need are much broader. So if you're running a warehouse or you're running a fleet of vehicles, of course, then your entire insurance portfolio changes because you then are in charge and you are operating those assets. Whereas with TESs, generally you battle to get insurance cover because you are not instructing those employees on a daily basis. So in summary, before we open up for questions and answers, just a few comments. in pulling it together. Firstly, Employment Equity Act reporting. Get your house in order, colleagues. You need to ensure, especially with the Amendment Act, that you are complying with Section 57 of the Employment Equity Act, that you and your client are reporting proportionately on the less or more than 3-month fixed term contracts. The next one is the harassment risk assessment. Colleagues, you need to ensure that the code of practice on harassment you are complying with, you create awareness, and in point 8.1, it actually requires you to do a risk assessment. Go and take a look at that and see if you are another ShopRite in the waiting. Grievance process. Why did I put your grievance process there? Remember, the code of practice on harassment says that if an employee is subject to harassment, they must have an alternative process to follow their rights. In other words, sometimes because it's your manager who's harassing you, you should have the opportunity to follow another channel, maybe directly to HR or to the TES. So make sure your grievance procedures are accommodating of harassment and related matters. Section 197 transactions, I've touched on that already. So if your client is going to outsource or subcontract its warehouse, and you've got TS assignees who are part of that process, they are part of the 197. They've got to transition automatically along with the other permanent staff. So it calls for a 197 agreement to be signed between the client, the TS, and the new provider. POPIA Act, of course, make sure that you sign operator agreements with your providers. In other words, your pension funds, provident funds, medical aids, payroll companies, IT companies, you need to sign operator agreements with your partners for credit, criminal reference checks, etc., etc. Then you need to ensure your employees in your employment contract, your FTCs, that you bind them to the POPIA Act and that they allow you to process their personal information. And then finally, as I said, please make sure that your disciplinary codes are reviewed regularly to keep pace with changes in new legislation, new labor court judgments, and also make sure that you ultimately align your disciplinary codes with those of your clients after 3 months, because your client is the deemed employer after 3 months. So colleagues, that was a mouthful. I'm going to leave it at that for now and open up for any questions and answers, albeit to you, through you to the colleagues. Thank you. Santi.
Thank you. Just one question that I have on the end dates on the employment contracts. Is it legal to say that there's no end date on it? There's a start date, but the end date of the contract, because we can't really say. I mean, the client initially says it's for 4 months or for 5 months or whatever. But then just say if the contract continues after 3 months, it would be as per client's requests. And that basically leaves it open for a year, 2 years, 3 years, or what? Is it, how legal is it to do it like that?
Santi, I'm very, very pleased you've raised that question. And I'm going to answer it by actually just calling up that section of the Act. Just hold on for a sec. I'm going to try and find it very quickly. But my short answer is you can't have a general provision in your contract that says you're employed until the client doesn't need you anymore. That would be a very big problem, because you can't have a general link between your fixed term contract and, you know, such time when your client doesn't need the person anymore. And there are quite a few judgments in that regard. So if you Santi, if you just take a look at this, just confirm that you can see my screen.
Yes.
So Santi, if you look at section 198, capital B of the LRA, it now talks about fixed term contracts, and especially for employees earning below the threshold. And they say a fixed term contract means a contract of employment that terminates on the occurrence of a specific event, and in fact, a specified event. So specified means clearly you've described it, you've specified. It's not a general provision, it's specific. The completion of a specified task or project or a fixed date. So the first thing section 198 capital B in the LRA says is you must understand a fixed term contract is a specified event. They then go to the following. It then says an employer may employ an employee on a fixed term contract or successive fixed term contracts for longer than 3 months only if, and Santi, you can see now where they're going. They say only if the nature of the work for which the employee is employed is of a limited or definite duration. And then look at what they say here. The employer can demonstrate any other justifiable reason. So the burden of proof at the CCMA or on a labor court is going to be, okay, employer, you prove to us that John knew that this was a temporary specified contract. And then, of course, as you know, Santi, it gives us specific examples. It says, without limiting this, a fixed term contract will be justified if the employee is replacing someone who's temporarily absent. There's a temporary increase in the volume of work. There's a student. There's a specific project. Again, the word specific project. Seasonal work. And so on and so forth. And then I'm going to stop on this basis here, Santi. And now what worries me here is this clause in subsection 5. It says, if you employ someone on a fixed term contract in contravention of subsection 3, it is deemed to be indefinite. So in other words, if you read the law specifically, if you don't specify the date or you don't specify the project and you link it just generally to till the client doesn't need you until the project's finished, I think you're going to have a big problem trying to demonstrate that the employee's expectation was clear. And as soon as you fail to do that, the status is indefinite. And when the status is indefinite, then you can't just remove John. You got to go through a section 189 retrenchment process.
Okay, I hear you, but I do think that we are then covered because it is specifically linked to a project. It is just a question of the duration of the project is not always definable, if that's the right word. I'm actually Afrikaans, but yeah.
No, you're right.
If you can't define, that this project, because what happens is that my client's client keeps on adding, tasks, which takes the project into or over the initial period. So the contract will not as a definite start date. It is linked to a specific project, but it's not there. There's no end date. It says that if it goes beyond the 3 months, then that would be as per the client's request, but it is linked to a specific project.
Yeah.
So then we're good.
Yeah, look, I think, Santi, before I'll be comments, I think for me, there are just 2 comments I want to make. The first one is, I fully agree. You can't always have a time period. So if you can say you're employed until this building is completed, type of thing, well, then it's fine, because when they lay the last brick, they know their job's over, or you're employed until the end of the peak season, which is envisaged to be mid-January. Those types of descriptions are fine. When you renew, though, so if your client's client says, oh my goodness, we've got another extension and there's another part of work and we now want you to extend the contract, Santi, please remember that the Basic Conditions of Employment Act requires you to put it in writing. The BCEA in Chapter 4, when it talks about employment particulars, it says if you change employment conditions or you change any of the terms of the contract, it's got to be committed to writing. And that's where a lot of companies go wrong. So they'll extend and they'll extend and they'll extend, but they won't back it up in writing and they won't explain why there's an extension. And then 2 years later, I'm still working there. And then I'm saying I've got an expectation. I'll be over to you.
I think the important thing to look at as well is whether these people are over or under the threshold, number one, and how many times do you roll over those contracts? That's where, and Kevin will probably explain it much better than I would, but that's where your risk lies. So a lot of the times what happens in our industry is that we will have this functional outsourcing business that comes from wherever, and that warehouse is now outsourced to them. And then they bring in TESs to supply. And they say, well, we've got a contract for 5 years with Pick and Pay, for argument's sake, in the DC. We want all of our forklift drivers, for argument's sake, there from your specific company. And then all of a sudden there's bad blood and they end it. But in the interim, they've given the guy 3 months under the auspices that they are trying him out and getting a feel for him, and then he's fine, and then all of a sudden you give him another 3 months, and that's where the real risk comes in.
Absolutely. Kev, over to you.
Thanks, John. Thanks, LB. I think the important thing is that your contracts need to specifically have clauses in it that particularly refer to, in terms of Section 198 processes or provisions, the justifiable reasons for an FTC. Those justifiable reasons are limited, and it's very important that you can identify your contract or the contract between yourself as an FTC and your employee for whatever duration it is, that those reasons are justifiable in terms of it being statified as an FTC, a fixed term. It's not an ongoing, it's not an open-ended contract. And I think the important thing also is that to avoid the open-ended process of things, because if contracts are rolled over, specifically if FTCs are rolled over, they become very difficult to manage, and the issues of interpretation of employment is also very blurred. So I think what you have to do to avoid that is to try and look for every opportunity to actually enter into a new FTC. And I know it's a lot of work, PT, but the reality is it cuts down the risk when you knock on the door of the bargaining council or you knock on the door of the labour court. The issue is it's very clear that the intention was never for this matter to continue on ad infinitum. Thanks, John.
Thank you very much, Kevin. And you make an important point. I think for me, colleagues, the very central proposition of a TES, if you really bring it down to its core, a TES must be an expert in the administration and management of fixed-term contracts. And if you are not managing those contracts by defining projects clearly, by reducing agreements into writing, by extending contracts, I think there you're losing a lot of credibility, because as Kevin says, if you don't manage that and if you don't put in that effort, the repercussions around unfair dismissal, bargaining council, compliance, and just in general, workforce morale and motivation and climate, I think you got a problem. And I think Section 198 capital B, which I put on the screen just now, that must become your Bible. And you must continuously say to yourself, are we managing our FTCs in alignment with that? And to Albie's point, if they're below the threshold, then it's even more important. If they're above the threshold, then reasonable expectation can be claimed. But if it's below the threshold, then you can't demonstrate specified duration, specified project, you're going to be in for the high jump, because immediately the assumption is that it's indefinite. Colleagues, with that in mind, I'm going to close off. Thank you very, very much. I hope that it was at least in part insightful. I hope you can use the content, and thank you very much for the invitation. Albie, Krista, Kev, and company. Cheers.
Thank you, John, and thank you for all of the participants and the questions. You know, I think the more you dig into this, it actually just shows you that we need to be the experts, and to be the experts, we need to ensure that we comply with all of these pieces of legislation, and ensure that we not only protect our business from that point of view, but also that of the client, and that makes us remain relevant. John, thank you. And if there's any questions, I think we can arrange that. If there's any further questions that you've got, or issues or clarification, that you feel free to send it to Krista, and we can look at other experts that we can, as an exco at the TESD, pulse to get answers for our members.
Thanks, Albie. Thanks, John.
Thank you, guys.
All the best. Go well.
Thank you.
Enjoy the day.
Bye-bye.
Thanks again.
Thank you.